Now, Jacob Zuma's lawyers have told the High Court in Pietermaritzburg that the former president shouldn't be made to suffer because of what they say are trumped-up charges. Advocate Thabani Masuku argued the corruption case is entirely cooked up.
Yeah, claims of misconduct by Zuma against the state was strengthened by allegations made by former Asset Forfeiture Unit head Willie Hofmeyer. In his affidavit, he says it was clear decisions about this case were being made from elsewhere.
The gravity of political interference was such that it was clear that the prosecution was being directed from not within the NPA but from outside. And paragraph 23 says, until he listened to the recordings myself, and this is Hofmeyer speaking, says until he listened to the recordings himself, Mshe had been unaware of how deep McCarthy's association with Ngcuka still was. Most senior members in the NPA, including Mshe, knew that McCarthy and Ngcuka were still friendly. We were aware of the extent to which Ngcuka, using McCarthy as his proxy, was involved in directing the Zuma prosecution and possibly other investigations and prosecution. It was Ngcuka, working with others, and not McCarthy, who ultimately decided when Zuma should be charged. That's a member of the NPA. Why is the court not wanting that to be subjected to a trial? Why should the rot that is set out in Hofmeyer's affidavit, which clearly shows that there's been criminal conduct by members of the NPA to the knowledge of Mr. Downer, be simply swept under the carpet? Because we say that a fair trial would require that those allegations are investigated, and Your Lordship, after oral evidence has been laid and has been tested and everything has been tested, you can come to the conclusion that that's speculation. That's irrelevant. That is. But before that, with respect, my Lord, that is not fair that Your Lordship decided to decide this matter on the basis of affidavits.
Well, Advocate Andrew Breitenbach says Zuma has no right to seek leave to appeal until he's been convicted and sentenced. Breitenbach says it's in the interest of justice for an appeal to wait until the end of the trial.
In the present matter, however, an appeal against the dismissal of the special plea, if Mr. Zuma is convicted, and only if he is convicted, and is then granted leave to appeal, is a means by which justice can be attained. And the reason is because when the evidence has been led, the impact, if any, of Mr. Downer's involvement in the fairness of Mr. Downer's involvement on the fairness of the trial can be assessed. Our third reason for contending that an intermediate appeal at this stage would not be in the interests of the justice is the following. It is clear, we submit, that it would not be in the interests of justice to permit such an appeal if the applicant for leave to appeal has poor prospects of success in the intended appeal. The reason for that is that the likelihood is that the appeal will be a waste of time. It will cause yet further delay, something to which I shall return in a moment. As I shall outline in a moment, in our submission, Mr. Zuma's intended appeal against the dismissal of his special plea does indeed have poor prospects of success.